It is irrefutable that manifest injustice is defined by the second-degree murder conviction of Crystal Mangum in the 2011 death of her boyfriend Reginald Day. Clearly, the baseless and vindictive prosecution was intended as payback for the black 2006 Duke Lacrosse sexual assault accuser against 3 white student athletes. Accusations a decade before support from the Me Too movement gained traction. What has enabled this grievous injustice has been a silenced media, mainstream, alternative, black press, online news, the entire gamut, and all working in concert to prevent the public from learning the truths of Miss Mangum's wrongful conviction and incarceration. Arguably the most shameful episode of Tar Heel injustice in jurisprudence annals, it is undeniably one of the most cruel, most corrupt, and most blatantly racist cases on the books. Several cases nationwide have relevance to Crystal Mangum's murder case. Cases in Nevada, Missouri, Georgia, and North Carolina, a bastion of racial injustice. In a Las Vegas courtroom during an alleged armed robbery kidnapping crime, celebrity athlete O.J. Simpson was convicted of the serious felonies in a case which seemed bereft of evidence or criminal intent commensurate with his 33-year prison sentence. Even former Los Angeles District Attorney Gil Garcetti stated he believed the lengthy prison sentence was payback for his acquittal in the murder of his wife, Nicole, and her friend Ronald Goldman. A 1991 jury in St. Louis, Missouri found pregnant Patricia Stallings guilty of using antifreeze to fatally poison her infant in 1989. A conviction netting her a life sentence without the possibility of parole. After giving birth in prison to a son who exhibited similar symptoms to those of her deceased infant, a scientific investigation was launched which revealed a genetic condition mimicked ethylene glycol poisoning. An honest mistake by a laboratory set the local district attorney on the prosecutorial path, and the scientific revelation set Miss Stallings free after 2 years of imprisonment. Northwestern University's Pritzker School of Law's Bloom Legal Clinic's Center on Wrongful Convictions covered the Stallings case with an article titled, quote, Patricia Stallings, sentenced to life without parole for a crime that didn't happen, unquote. The same could be said for Crystal Mangum, being sentenced to a minimum of 14 years for a crime that didn't happen. On February 23, 2020, African-American Ahmaud Arbery was confronted by 2 armed white men while jogging a couple of miles from his Brunswick, Georgia home in the middle of the day. The father-son duo claimed to have attempted to make a citizen's arrest when Travis McMichael, the younger, fired 3 times at Mr. Arbery, 2 of the shots fatally striking the unarmed jogger. And local law enforcement took no action against Travis or his father, Gregory McMichael, who was at the scene with a handgun. They were not arrested or charged with the crime. It wasn't until a New York Times writer from the Atlanta Bureau broke the story nationally that a public outcry finally forced an arrest and murder charges against the two more than 2.5 months after the incident. On May 7, 2020, a rare rehearing en banc took place by teleconference with the Fourth Circuit Court of Appeals in Richmond, Virginia, to hear the North Carolina appeal of Ronnie Long following a denial by the 3 appellate judge panel. Mr. Long, an African American, had been convicted in 1976 of raping the wife of a mill owner in Concord, North Carolina. With no direct physical evidence linking him to the crime, prosecution findings hidden from defense counsel, and a prosecution mainly driven by the victim's eyewitness identification, Mr. Long was convicted and sentenced to life in prison. After decades of incarceration, Mr. Long, who had steadfastly maintained his innocence, received media coverage that generated support by many groups, such as the NAACP and individuals. The Innocence Project at Duke University ultimately got involved and led the fight for a new trial, which fortunately secured an en banc hearing, that is, a hearing by the full 15-member federal appellate court. A ruling is expected in the summer of 2020. Like O.J. Simpson's 33-year prison sentence, the Crystal Mangum murder case is nothing more than a vendetta prosecution against her as payback for her allegations of sexual assault against 3 party goers at the March 13, 2006 beer guzzling, stripper oogling spring break bash in Durham. Mangum has been steadfast in saying she told the truth about being sexually assaulted at the party, and unlike many sexual assault cases of notoriety, such as those involving Harvey Weinstein and Bill Cosby, the identity of the 3 perpetrators was not a certainty, as there were approximately 50 white males at the party. Although Miss Mangum did her best in the photo lineup, there could have been mistaken identification. It is well documented that cross-racial, cross-cultural eyewitness identification can be extremely unreliable. No other case better illustrates this than the North Carolina case of Ronald Cotton, the African American who white rape victim Jennifer Thompson picked visually as being her assailant. During her horrific ordeal, Miss Thompson did her best to permanently imprint on her brain the facial features of the rapist. In the end, Mr. Cotton was exonerated by DNA evidence. Bottom line is that it is possible that the 3 Duke Lacrosse defendants were innocent of sexually assaulting Mangum, and that Mangum was telling the truth about being sexually assaulted at the party. The two are not mutually exclusive when the possibility of good faith misidentification is taken into consideration. However, the mainstream media has proclaimed as established fact that Miss Mangum lied about being sexually assaulted. She is often referred to as the false accuser. As recently as May 11, 2020, journalist Megyn Kelly, during an interview with Court TV Live special contributor Ashleigh Banfield about Joe Biden accuser Tara Reade, stated as fact that Crystal Mangum lied.
Do you think then that there is an evolving standard for hearing an allegation of sexual harassment or abuse versus believing an allegation of sexual harassment or abuse?
Well, I would hope there's an evolving standard on believing. I mean, people may think I'm one of those believe all women people because I've been an accuser, but I'm not. I'm a lawyer at heart. You know, I practiced law for 10 years. And I believe in due process. Not every woman who comes forward is telling the truth. We saw that in the Duke Lacrosse case. We've seen it in other cases.
It should be noted that Miss Kelly stated that in her interview with Tara Reid, she thought it believable that Miss Reid could, for years, accuse Mr. Biden of sexual harassment only, and then suddenly morph her complaint into a criminal sexual assault.
You give an interview to your local paper, right, and you don't tell the full story. You only tell about the alleged harassment, and you don't mention the alleged assault. Why not?
The first question that was asked of me was, well, it wasn't sexual, was it? And that's all it took. I was so encouraged, and it'd be the first time I've been telling the story. It kind of took my breath, and I thought, okay, I can't really talk about what happened. And then as soon as the local article came out talking about the harassment, within hours, before it even hit the paper, I was being called a Russian agent.
And for anybody who's sort of coming into the interview with you and me and has seen snippets or pieces of the interview with Tara that you did, I mean, in broad strokes, the story is that about a year ago, Tara came forward to some reporters with a story of harassment where she alleges Joe Biden touched her hair, her neck, and her shoulders in a way that made her feel uncomfortable. She complained about it and felt retaliated for that. And in some aspects, the criticism of Tara has been that perhaps when she didn't get enough media traction for it, almost a year later, she upped the ante with a much more serious and many would say criminal allegation of this sexual encounter and assault with a penetration in a hallway on the Capitol grounds. Have I got that correct in terms of the layout?
Yes.
So for that reason, as a lawyer, I know you look at things so meticulously, down to the timing. What do you make of this evolution of her story and also the timing of driving it out?
I would say the evolution, that's not what bothers me about this case, because you know, if she had just told in April of 19 when she first came out, harassment, and then came out later as she did with, and also assault, I can understand that. Women, they take time to tell the full story. We saw that in the Weinstein case with a lot of his victims. So to me, that's understandable. It doesn't bother me as much. And her explanation is the reporter who she first told the harassment story to was, she felt he was kind of aggressive, and the first question was, well, it wasn't sexual, was it? And she was like, no, it wasn't. So that's her story. I don't find that implausible. I don't know whether it's true. I've seen it happen before. I think Tara Reid's biggest problem is believing that a sitting U.S. senator committed a sexual assault in the middle of a hallway, in the middle of the Senate office building, in the middle of the week, in the middle of the day, in a hallway where, according to Tara's story, he was just talking to someone moments before he allegedly committed the assault. I think that's really tough to get past because it's so incredibly reckless, right? It's just so incredibly reckless, and we haven't seen him have a reckless life.
Megyn Kelly never interviewed Crystal Mangum and has likely based her opinions about the Duke Lacrosse accuser solely on the words of then North Carolina Attorney General Roy Cooper in 2007. What people don't know is that the 6-hour interview Crystal Mangum gave in late March 2007 before the Assistant Attorneys General Mary Winstead and James Coleman is that it was never recorded by audio, video, or transcription. No record of Mangum's interview with the Attorney General's office exists. Mangum's attorney at the time, Anita Hunt, of Durham's Hunt Law Firm, tried to obtain a disc or transcript of the interview and was told that there was none. Because Hunt did not believe that such an important interview would not be recorded, she asked Crystal Mangum to try and obtain a copy. As with Attorney Hunt, Mangum was told that the interview was not recorded. Had there been a recording, it would have demonstrated how the two attorneys general browbeat, grilled, gave the third degree, and were confrontational towards their witness, Mangum. So it is not unreasonable that they held the interview for nothing more than to be going through the motions. On April 11, 2007, Roy Cooper, though not a judge, proclaimed the three Duke Lacrosse defendants to be innocent.
The result of our review and investigation shows clearly that there is insufficient evidence to proceed on any of the charges. Today, we are filing notices of dismissal for all charges against Reed Seligman, Colin Finnerty, and David Evans. The result is that these cases are over, and no more criminal proceedings will occur. We believe that these cases were the result of a tragic rush to accuse and a failure to verify serious allegations. Based on the significant inconsistencies between the evidence and the various accounts given by the accusing witness, we believe these three individuals are innocent of these charges.
Gubernatorial aspirations likely led Attorney General Cooper to not only disparage Crystal Mangum, but to attack Durham DA Mike Niflong, who prosecuted the Duke Lacrosse case. In a bipartisan effort, he joined North Carolina Republican Congressman Walter Jones in asking the United States Justice Department to initiate a criminal investigation into Mr. Niflong for violating the civil rights of the three Duke Lacrosse defendants. Wisely, the United States Attorney General declined. Make no mistake, Roy Cooper is the main driving force behind the vengeful persecution of Crystal Mangum.